Facebook has been hit with a lawsuit from Yahoo for patent infringement. Yahoo has accused Facebook of infringing 10 Yahoo patents. This is not exactly surprising. It's very often the case that companies, startup companies, as soon as they have money in their pocket, as soon as they've achieved their IPO and raised finance, they become the target of patent infringement lawsuits. In this case, the suit comes from Yahoo. Now, what Facebook needs now is patents that Yahoo is infringing, so that Facebook can go back to Yahoo and say, we may be infringing 10 of your patents, but here are 10 of our patents that you're infringing. Often when that happens, the two parties, if they can see that each side has an equal amount of ammunition, they may agree to a truce and they may agree to a cross-license, and the dispute is settled through negotiation. But for Facebook to do this, Facebook needs to have patents that read on Yahoo. Now, what I'm going to argue today and explain is why Facebook needs patents today, but startup companies in the earlier stages of growth do not need patents, and explain why startup companies often waste their money filing patents too early. Now, the patent wars are clearly wars for the big boys. You have to be a large company, you have to have very deep pockets, you have to have a stockpile of weapons if you're going to enter the patent wars. And the weapons are patents. Patents are weapons of litigation, and they're pretty much only weapons of litigation, as we'll explain. And if you're going to get into the patent war game, you need hundreds or thousands of patents preferably, and you need to have tens of millions of dollars or hundreds of millions of dollars set aside for legal fees to support your patent assertion claims. It's a very expensive business. Now, there is a myth that startups need patents. I've been in the startup business for 30 years now. I've been in the patent business for the last 7 or 8 years, and I can tell you that in most cases, startups are wasting their money when they're filing and prosecuting new patents, and I explain to you why. Now, one of the theories that's presented as to why startup companies need patents is that it will protect them from competition. The issue here is that if you're going to assert your patent, well, firstly, the patent does not give the company the right to build the product. Products today often contain many different inventions. A smartphone is estimated to have several 100,000 patented inventions inside a cell phone. So if you're going to be manufacturing and selling a smartphone, you're going to be infringing someone's patents. So, but if you have a product that has very few patents, patented inventions inside it, that's a different story, as we'll come to. But the point is that if you want to assert your patents, you are going to need to pay the legal fees to bring the case to court, and you're going to have to present a credible threat. And the average cost for a plaintiff bringing a case against a defendant for the cost of the patent holder is around $3 million. So if you want to go after multiple defendants and protect your product that you're shipping as a startup company using patents to restrict competition, you're going to have to set aside tens of millions of dollars just for legal fees. So if you don't have a war chest of funds, you don't have an army of lawyers, your patents as a startup company are pretty useless for that purpose, and for the purpose of restricting competition. Now, there's another theory that's presented by often the advice that startups get come from patent prosecution attorneys. These are the attorneys that are filing patents on behalf of companies, and obviously many companies need patents and their services are very valuable. But the patent prosecution attorneys are primarily involved in negotiating, building patents and negotiating, getting them approved by the patent office examiners. They're not the people that stand up in court and assert the patents in court. The patent litigators are the ones that, if you're a startup company, get some advice from patent litigators. Obviously, you can take advice from patent prosecution attorneys, but the litigators will tell you what happens in the real world when it comes to actually asserting the patent from a startup company or from after the company's grown. So the theory is that you need to have patents in order to help you to raise finance from investors, because investors like startup companies with patents. Well, I assume an investor, if they're looking at a company with patents or a company without patents, will probably think, yeah, well, the company with patents is more interesting. But generally, the investors do not understand how patents are used in the real world. I was discussing this with an investor who'd been very experienced over several decades, had been a venture capital investor, been quite successful. And he explained that it was only recently that he realized that the patent was an exclusive right. It was a right to exclude other people from practicing an invention. It was not an inclusive right. It didn't allow the startup to practice the invention and didn't give the startup freedom to operate within a field. The patent basically only allowed them to restrict other people. And when he realized that the best thing you can do with patents as a startup company is probably sell them to someone else that can use them, which we'll come on to in a little while. Of course, there are some startups that do need patents. If your startup is producing a product that has very few patented inventions inside it, so maybe if it's a drug or a medical device with a very unique design, then you could file a patent and it would probably protect you, and it will probably be very important if you're in the pharmaceutical, medical device type business. Now, the other business model that needs to consider, that obviously needs patents, is if your business is licensing patents. If your business model is driven by building patents and licensing out, which many companies are today, then obviously you need patents. But for all those other companies in the high-tech space, software, internet, semiconductors, all those different spaces, often they're wasting money and filing for patents, because once they get the patent, they don't have the ability to assert the patent against infringers. They wouldn't even be taken seriously if they approached an infringer unless they had serious lawyers and budget for patent litigation available to them. So why don't startups need patents? Well, the first thing is, if they don't have an army of lawyers and they don't have a war chest of funds, then the patents are pretty useless. The only thing you can do with a patent is assert it against an infringer. Yes, you can file child applications, and child patents can grow from parent patents, but then all you can do with them is assert them against infringers, because patents are exclusive rights, as we mentioned. So if you don't have the funds, if you don't have $3 million at least set aside to assert the patents, then the patent's pretty useless to you. Now, the second issue for startups is the timescales involved here. I have a patent that issued in my name. It took 10 years to get the patent through the patent office, and that's not totally unusual. If you consider that the average lifespan of a startup is 7 years, after 7 years they're either dead or they've IPO'd and become the next Facebook. So the startup lifespan, the startup's often dead before the patent has issued. So there's a real problem there in the timescales involved when you're considering prosecuting new patents, applications through the patent office. Now, of course, you can buy a patent within a few months, actually. So the patent acquisition strategy can be much quicker and more effective than the strategy of prosecuting new patents. And that's the issue for large companies now. So Facebook will be aggressively looking to acquire patents now in order to use them in counterclaims against opponents such as Yahoo. Now, I did a polling, I've discussed this and spoken to several investment banks in Silicon Valley that are involved in selling or acquiring startup companies, technology companies. They're in the merger acquisition business, buying and selling or helping their clients to buy or sell technology companies. And I've asked them how they assess the value of patents when valuing a company for acquisition or for sale. And the general rule, believe it or not, is that when it comes to merger acquisition, they look at the business, they look at the technology, and they provide little or zero value is attributed to the patents. They do not value the patents in merger and acquisitions of startup companies. Now, there are scenarios where the patent buyers, there seem to be different types of buyers out there. The merger and acquisition buyers do not value patents at all. And on the other side, the patent buyers don't really value the businesses at all. So if you're considering filing patents for your startup company in order to support a valuation, it is really very unlikely to happen. Almost all the investment bankers I've spoken to said they don't add value to the startup company based on the patent portfolio. It doesn't factor into their calculations of value. So, if you are a startup, how can you protect yourself? If you're not going to file patents, is there anything else you can do to protect yourself from competition? Well, obviously what you don't want to do, if you have an idea for a new invention, you don't want a competitor to go and patent the idea and then restrict you. A large company could patent the idea and then keep you out of the market because they have the lawyers and the war chest of funds in order to assert the patents against you. Now, what you can do is disclose your invention to the world. You can write a paper or publish an article, and this can make the patentability void. So if you disclose this to the world and you publish an article or write a paper that is made available and placed in the public domain, this can restrict your competitors from filing a patent on that idea because they weren't the first to invent and you were. So that's something for startups to consider instead of filing patents. Of course, if your business, if you are an expert in patent prosecution and you can file patents very quickly and easily and you're in a startup business, obviously you might go ahead and just file those patents if you can do it without incurring a significant cost. But you're still going to hit these factors of what do you do with the patent when it gets issued. So, small companies that already have patents, what are they supposed to do? Well, one of the best options for them is to sell the patent with a license back. Now, selling the patent can inject cash into the company, and in a startup situation, the cash is often much appreciated and much needed. Now, this then allows the company to sell more products, accelerate selling the products. The license back means the company, the startup company, is not infringing their own patents. And they can then allow the buyers of the patents to assert them. Now, if the buyer is going to assert the patents against infringers, this is going to restrict competition and it can actually benefit the startup company. So for many startups, selling the patents with a license back is a win-win situation. And the license back is almost always provided by the buyer. Essentially, the acquirer is buying the rights to assert the patents against the whole world except the startup seller. So this is a strategy for many startup companies that can provide a win-win scenario. They're making use of these underutilized patent assets, they're injecting cash in the company, and they could be restricting competition when the patents are asserted by the new owners. So, unless your startup is in the medical or pharma space, or the business model you have is patent licensing, it may be a mistake, and it's often a mistake, to waste startup funds filing patents. If your startup already holds patents, you can inject cash into the company by selling them with a license back.